Welcome to the Mourning Feed. So, I wanted to share this clip just because it was really kind of bittersweet to see this kind of play out. For anybody who doesn't know, I'll give just a little bit of background. A lot of people know both of these cases, or at least one of them. Um, and a lot of people clicking on this will likely already know the cases that we're talking about. But Dan Markel was a law professor who brutally lost his life um, in 2014 when his life was taken allegedly by a hired hit from his ex wife over a very contentious custody battle. A lot of those people that were involved have already faced trial, including the hitman, including um, the ex wife's brother, Charles Adelson. It's a hugely popular case, so I won't go too much into it. However, the name Dan Markel came up in another unrelated case recently at trial, actually at the sentencing phase of trial. And so I just wanted to bring that up and talk about it for just a moment and show the clip because for those who know and love Dan Markel and for those who know and love Quinton Simon, it was just a really bittersweet, heartwarming kind of moment to see. And I think for me personally, the reason why it was so kind of heartwarming in a way, it's an odd thing to say. You have a law professor who brutally lost his life through a hired hit, and his name being brought up and his work being quoted as a law professor at the trial, the sentencing phase of the trial, for a child who brutally lost his life far too soon. So Quentin Simon is over in the neighboring state of Florida, Georgia, and he was reported missing. When he was reported missing, everybody started paying attention to this adorable little boy in Georgia who nobody could find. But the situation, the circumstances that was being reported by the family seemed very off, very disturbing. Their interviews just really made everybody kind of give a side eye, like, what's really going on here? Law enforcement came to find out later that the little boy's mother had taken his life, and she was just convicted by a court in Georgia, or by a jury in Georgia. So at this trial for Quentin Simon in the sentencing phase, they're going over, whether or not, where the state stands, where the defense stands on sentencing, and whether it should be life with or without parole. Now, for a lot of people who follow the Dan Markel case or know him personally as a friend, you'll know that he has spoken on these matters at length. And we're going to play two clips for you. I'm going to play a little clip of Dan Markel speaking about this very topic, and then one from the trial where the prosecutor actually mentions Dan Markel's work on this topic when trying to plead to the court for life without parole. And I feel like this is so important. I'm going to go back to my statement just a few moments ago about why this is personally heartwarming for me. For those who knew Dan Markel, they know how much he loved his children and how important they were and how important their futures were and how he was a very present father. And for his name to be brought up in the trial of this child who clearly needed a Dan Markel in their life. They didn't get one while they were still alive. They needed one. There are a few people who did show up for Quentin Simon in his life, and I'm sure that he was very grateful for those people in his life. But it was just a very, very bittersweet moment to see Dan Markel's name mentioned at the Quentin Simon trial. And so for anybody who follows either case or has followed Dan Markel's work, I just wanted to put this out here for anybody who may have missed it. So enjoy both clips. I'm going to show a clip of Dan giving a similar discussion about this topic, and then I'm going to show him actually being mentioned at the trial. So enjoy a little moment of Dan Markel's work showing up for a child in need. and justice that very much was in need. Now, just as a conclusion, real quick, for anybody who follows these cases, if you're aware of one and not the other, maybe you want to know what actually happened. So at the trial, after Leilani Simon, the mother of Quinton Simon, the little boy in Georgia, after she was convicted at the sentencing phase, both sides made a pretty impassioned plea for their opinion on what should happen to Leilani Simon. Of course, the prosecution wanted no parole. The defense wants her to have the option of parole, and they presented what they believe their mitigating factors were. Typically, when you have the loss of a child, victim impact statements and things like that are very difficult. They're always difficult when there's a loss of life, and you have people showing up who loved that person. But when there's a child, it's even more. It's difficult even on the public, who have no relation to it. It's just very difficult to hear when you have people speaking about a child who lost their life in a brutal way. These victim impact statements at Leilani Simon's trial were they were very heart-wrenching in a number of ways. The court got to find out and hear about how drugs had played a major part in the family, and Leilani's mother, who does not have a very good public perception of herself at this point after the disappearance of Simon. Initially, it was claimed to be a disappearance, and she took a lot of heat for different things that she may have said or ways she acted, or the fact that she is kind of she bears some responsibility in the fact that Quinton was even with Leilani Simon, his mother, at the time, when he really shouldn't have been. So it's a whole long story, but this woman, who does not have a very good public image, got up on the stand and gave a very impassioned plea about everything that her drug use had robbed her children of. Leilani Simon has a brother who's also serving a very similar sentence. So I do believe that there are some pretty heavy mitigating factors when it comes to how this all played out. But the facts are the facts. She did what she did. And you're going to see when the prosecutor brings up Dan Markel's quote and his work, you're going to see his response to that. Yeah, there are difficult situations here. However, it is okay to sentence somebody because they did a really bad thing and because that is the sentence that they deserve, which makes me think of a lot of cases right now and how certain justice systems within certain departments within our justice system, rather nationally, are really pushing back on that. And a lot of people see these campaigns, like the Menendez brothers campaign, and they think to themselves, they start questioning how we sentence and how we come to those decisions on how long a sentence should be. I just want to point out that this is going to be a huge topic in our country for a little while to come. There are a lot of departments that are pushing back on sentencing, and their goal is they don't want these heavy lifetime sentences. They want to go with more of a 20-year max type sentence, and that is unfortunately not suitable in so many cases. I wish we had a society where life sentences were not necessary. But as the prosecutor makes the point, it's okay to punish people because they did a really bad thing, and that's what they deserve. That's very hard. That's why sentencing in these trials, people think, oh, the family finally got their justice. It's never a good day. The family walks out of there thinking, I don't have my family member. Someone else's family is also now ripped apart. they found out some secrets that they never, ever wanted to even know exist, let alone exist within their family, by their family member, doing this action. No one wins in these situations. It's not as if a life sentence is something to celebrate. Nobody celebrates it. Ask any of the families that have gone through this how satisfied they felt on sentencing day or on the conviction day. The only satisfaction they feel is validation. You are valid. This happened to you. We recognize that. We've prosecuted that. 12 of your peers in your community have agreed. This is valid. This deserves a punishment. Validation, I think, is about the only thing that you actually get as a victim when somebody is sentenced or convicted. So no one enjoys this. It's done because it's necessary. If you look at some of the places in the country where we have let people out far too early, or let people out maybe when they shouldn't have been ever let out, follow those cases. There's not a lot of them that end well. So anyways, this is definitely obviously a topic that's on my mind, but I don't want to get into in the weeds here. So I'm going to let you all watch this little moment here where Dan Markel was mentioned at the Quinton Simon trial, and I hope that some of the other friends and supporters of Dan Markel enjoy seeing this if they happen to miss it.
So let me give you some examples of what I think fall under these kind of labels that I've been using. So murder, for example, is a kind of law that I think everyone agrees on. It would count as a necessary feature of any criminal law to be just. You'd have to have a law like that. There's an interesting question about drug possession, gun possession, possession of burglar's tools, right? So these are all things which are not, in the language of my interlocutors, folks like Moore and Husak, which the possession of which is itself morally wrongful, right? The question is that those are often sort of risky or thought to be somewhat risky in terms of their likelihood to endanger other folks. And so my view is that would fall under the realm of, they could be smart laws, they might not be smart laws in terms of whether they are effectively going to diminish these kinds of risks. But my view is that for the most part, prohibitions on the possession of those kinds of things, burglars' tools, guns, or drugs, would fall within the realm of the permissibly dumb. Whereas something like a prohibition on chess, right, at all time, for which there would really be no way you could offer the grounds of what I would call like it's a tweaked version of rational basis with bite scrutiny. A prohibition on chess, a criminal law that would ban chess, strikes me as lacking any possible rationale. Now, the drugs, guns, and burglars' tools, so the moral retributivists would say, well, those are all not really morally wrongful. We shouldn't have criminal laws condemning that behavior. You can have regulation. And I try to explain why the regulation approach is, probably preferable, but nonetheless not something that is required at the exclusion of the criminal law from weighing in on some of those things. And then there's other examples that I go to, such like eating on the subway, right? That's here we are in DC, where eating on the subway has at times led to people being criminally liable. And I argue that would actually also fit within the permissibly dumb, but it's not spectacularly dumb. And so those are my intuitions, and I try and flesh out what the significance is. But the fact that something is permissibly dumb is only the beginning of the inquiry, right? So it might be the case that what we need to do in terms of sentencing is look at whether something passes a rational basis with bite scrutiny, as I call it, in order to warrant a very, very light penalty. But if you wanted to impose a more substantial penalty, I argue that we should actually have, the moral equivalent of a tiered approach, such that the more punishment you wanted to impose on someone for a particular kind of conduct, the more intense the scrutiny we owe as citizens or as officials to the underlying prohibition. So it seems to me that drug possession itself could be plausibly criminalized under this approach, but it would not be something that could trigger substantial punishment. Thanks. On the other hand, theft or rape or murder, right? Those would be the kinds of things that I think could withstand even the moral equivalent of strict scrutiny. And so more intense punishments like incarceration would be appropriate.
Worry about this at any point. There were a million off-ramps. After killing Quinton, she could have just not thrown his body in a dumpster. You know, we get these abusive head trauma, child homicide cases. In typically, the fact pattern is the perpetrator does the thing, they do the act, and then they just say to the police, "Oh, you know, I found him in the crib like this, and I don't know why he's not breathing, or there was some sort of accident or something like this." She could have played it that way after killing Quinton. She could have. So that's like off-ramp number one, is just don't throw him in the dumpster. Don't do that. And at any time, she could have stopped telling lies, just refused to talk at all. Certainly didn't have to blame anybody else. She could have just said she didn't know. Certainly didn't have to blame like 3 or 4 different people. So she doesn't seem sorry at all, and she's taken no responsibility, and she seems to sort of think that she's kind of at least playing as though she's the victim. I would ask the court to look at this letter to WTOC and really read it, in which she's playing the role of like a detached commentator evaluating the evidence, and she'd sure love to know what happens, but you know the problem is she just keeps running into these gaps in the evidence, and that's really frustrating to her because she wants to know what happened. And it's just so infuriating and bizarre because, you know, obviously she knows what happened because she's the one who did it. It is bizarre, it is infuriating, and it is quite frankly insulting to everyone's intelligence, and really makes a mockery of the process. There's been this effort to blame it on drugs and mental health issues. Mr. Hilliard is too smart and savvy and experienced to try to do that directly, because I think he knows that you don't come in and say, "Judge, it was the drugs." But some of the witnesses maybe don't have that level of experience and were willing to just say it was the drugs. The drugs did it. To medicalize it, to kind of shift responsibility from her onto her conditions or these substances. Lots of people have tough upbringings. Lots of people take drugs, but very few of them kill their own child. We're familiar with words like homicide, killing somebody else, suicide, killing yourself, fratricide, killing your brother, or biological, or your brother in arms. Even infanticide. There's a word for this that the court may or may not know, filicide, killing your own child who's not an infant. A lot of people don't know that word, and the reason a lot of people don't know that word is it just doesn't happen often. It is a heinous thing to do. So heinous, in fact, that people do it very infrequently, and that's what she did. The drugs did not do that. I'll point out something about the drugs in this case. It's easy for people to get up there and kind of say, without really examining like how this would work or what this really means, is, oh, you know, the drugs caused her to do it. Let's look at the substances that she was on that night: cocaine, Percocet, marijuana. None of these substances are the kind of substances that are going to induce like a psychosis and essentially turn you into a different person or make you do something that you have no control over. You hear about that sort of thing, I guess, like bath salts and things like that. But that is just that's not what she was on. It wasn't anything like that. And it's a total red herring to say that the drugs did it. What she did to him was something that was inside of her already. It was inside of her already. Maybe the drugs lowered her inhibitions. Maybe they acted as an accelerant. Maybe they're like, the match to the candle or something like that. But they didn't cause her to do what she did. She did it. The drugs are not responsible for it. She is. She just did a wicked thing, and she needs to take responsibility for it. And so our recommendation is a total sentence of life without the possibility of parole, plus 65 years and a fine of $117,000. The maximum that I calculate is available under the law. I've emailed the court separately that the count by count breakdown. I won't go through that here, and the justification for the fine. That is essentially our goal there is to ensure that if the defendant ever attempts to profit from her crimes by signing a book deal or taking a paid interview, that there will be an existing financial obligation that will cause at least some of the money, up to $117,000, to be diverted to defray some of the costs associated with her conduct in this case. Now, that brings me to kind of the last question, which is really separate and apart from whether the court judges a fine here, is why life without parole and not life? That's really the only question, is whether the court is going to impose the additional punishment of the life sentence never being parolable. And it's a reasonable thing for the defense to say, gosh, life is a serious sentence. 30 years before you become parole eligible is a long time. And that's true. And we are here asking the court to go above that and to impose the maximum. And I'd like to kind of defend why and argue why. When we talk about sentencing, we talk about the principles of punishment. There are a number of them. We learn them in law school, and they come up in sentencing arguments, and Mr. Hilliard has gestured at some of them, rehabilitation and things like that. And I'll just kind of walk through these. One of the principles of punishment that we talk about is incapacitation, which is incapacitating the offender from committing a similar offense. Somebody is so dangerous, they just need to be locked up to keep them off the street. Now, can I say that incapacitation, the need for incapacitation, justifies the additional sentence of life without parole here? Not really. I don't think that principle of punishment is a justification. That she's so dangerous that life with the possibility of parole is not sufficient. Next, we have deterrence, both specific and general. Specific deterrence meaning the need to have a serious enough sentence that it deters her from doing something similar, and general deterrence, that it deters other people in the community who might contemplate doing the same thing from doing it. I don't know that that's really in play here either. I don't think she needs life without parole versus life to not do it again. And I don't know that there's anybody out there who's contemplating killing their child who's going to go through with it if she gets life without the possibility of parole, but won't go through with it if she gets life without the possibility of parole. And then we have rehabilitation, the need for rehabilitation. I cannot say that there's no chance she could be rehabilitated, that she's totally beyond rehabilitation. I think the court could reasonably find that. I think there's a lot of evidence here that she is incorrigible. But I can't say for sure that after 30 years, she's so beyond the hope of rehabilitation that she has to stay in on that basis, that she just can't be rehabilitated. And so where we end up is at the last principle of punishment that I know of, and that is retribution. Punishment because you deserve it. A harsh punishment because you deserve it by virtue of what you did and how you acted. Not dressed up as being, towards rehabilitation or towards deterrence, but just punishment as a matter of moral desert. This sometimes gets a bad rap. I've heard it described as the least morally defensible principle of punishment. That somehow punishment dressed up as being for rehabilitation or being for deterrence is somehow morally acceptable. That punishment simply because you deserve it, because of what you did. But I don't think that's right. I don't think that's right. For one, it is the principle of punishment that, to the state's view, most lines up with the average person's intuition about what punishment is for and their concept of justice. It is actually okay and right and good to punish people harshly simply because they deserve it and not justify it further. You have to get really educated to learn that universal moral intuition is actually a bad thing or somehow wrong. Now, we sometimes kind of accept that what people say about retribution, retributive punishment, is true, that it is less defensible than the other principles of punishment. But there's not a consensus on this. That is actually not the consensus view. There are a lot of very smart academics and legal philosophers who continue to defend and make the case for retribution. There's an article by a legal academic, Dan Markel. He's a professor at Florida State Law School. Coincidentally and tragically, he was actually murdered himself. But he wrote on retributive punishment. In a 2011 article that I found, he talks about how it has both a communicative function and an expressive function. That punishment, retributive punishment, because you deserve it, a harsh sentence, just because you deserve it and you did a really bad thing, communicates to the defendant the seriousness of what they did and society's lack of acceptance for it. And it performs an expressive function too. It communicates to the defendant the seriousness of what she did, and it forms an expressive function. It expresses to society how seriously the court takes behavior like this. And I've got some long quotes in here from these articles. I think I will not read them. I think I will just kind of restate that in my words. Another way of saying this is that a severe sentence, here the harshest one under the law is what we're asking for, sends a message to both her and to the community. And she needs the message. Quite frankly, she needs the message. She doesn't get it. She needs to receive a solemn statement from the court that for an offense like this and for aggravating circumstances like this, the only punishment that will do, the only punishment that will adequately get through to her the seriousness of what she's done and just how unacceptable her actions are, is the maximum sentence under the law. That appears to be, at this point, the only thing that the court can do to try to get through to her. This letter to WTOC is dated September of this year. She still doesn't get it. And the court should send her a message. One, this is nonsense. And two, you deserve the most severe sanction that the court can lay on you. The court should send the community a message too. To the people that cared about Quinton, who knew him during his life, he was a child in their lives, and to people who came to know him only after the defendant killed him. And why do these people care about him? Simply because he was a child in their community, and that is enough. The court should send a message to them that their intuition about how monstrous it is for a mother to kill her own child and then act like she acted in the aftermath, and what the price tag for that ought to be, that intuition that they have is entirely correct and is shared by the justice system and by the court, which is really their justice system and their court. Thank you, Your Honor.